Hi guys, I hope you're all safe and well, and today I will be doing a video on the evaluation of murder. So I'm going to have a look at some of the key issues that are surrounding the law and some of the Law Commission's proposals to change the law. Now, when we started this topic, you had a look at one of the main issues, which is the mandatory life sentence and how it doesn't always take into account blameworthiness of the defendant, which you've seen through the case of Inglis and Gotts. We're going to have another look at that issue, and I'm also going to talk you through another 4 issues that the Law Commission identified in their 2006 report. Now, you have a copy of this report in your handout, so you can either use the report and follow along with this video, or have a read of it after the video to consolidate and answer the A03 questions. One of the key quotes from this report that I think really sums up what the Law Commission think about the law is as follows. The law is a rickety structure set upon shaky foundations. Some rules are unaltered since the 17th century. Other rules are uncertain because they are so frequently changed, there is no clarity. Okay? And the end part of that quote about the rules being frequently changed and there being no clarity is the first thing I'm going to discuss. So if you think of the definition of murder, it's from Lord Coke in the 1600s. There is no Murder Act, so Parliament have had very little say on the law of murder, and it has basically developed through cases. Now, one part of the law that's fluctuated quite a lot is the mens rea element. So if we think back to the mens rea of murder, remember this can be proven by the prosecution through something called either Malice Aforethought express or Malice Aforethought implied. Now, for this issue, I'm going to focus on Malice Aforethought express. And there are 2 parts to this. The first part is direct intention. Now, this is quite straightforward. It's the defendant wanted to kill the victim. It was their aim, want, and desire, and it can be proven quite easily. So, for example, Bill wanted to kill Tim. He drove to the shop, bought a gun, drove to Tim's house, shot him in the head, and he died. All right, it's a pretty straightforward chain of events. Then you've got something called oblique/indirect intention, where the defendant's principal aim wasn't to kill the victim. However, they foresaw that by carrying out their act, death was a virtual certainty, and they've gone ahead and done it anyway. This is also Malice Aforethought express and sufficient for murder. And this is where the issues lie. So if oblique/indirect intention is found, that can be called foresight of consequences. And there was a little bit of discussion and debate as to whether, if foresight of consequences was there, the jury had to return a guilty verdict, or whether it was up to the jury whether they wanted to return a guilty verdict and foresight of consequences was merely evidence for them to do this. So if there was foresight of consequences, must the jury say the defendant is guilty and has the mens rea, or can they choose not to? And it came to a place where it is a little bit more certain now through the case of Woolen in 1998, which is the leading case on mens rea for murder now, and Matthews and Elaine, which confirmed this in 2003. So the position now is that it's up to the jury to decide. So the jury can find indirect intention if they think that death was a virtual certainty and the defendant realised this. However, this still hasn't been approved by Parliament and there still is no act. Therefore, if another case came to court and was appealed up to the Supreme Court, this could then change again. Okay, so there's call for Parliament to clarify this. Also, this has brought on another small issue of moral dilemma. So the fact that foresight of consequences is merely evidence of intention, and the fact that a jury could actually decide not to convict the defendant, even if they think they had indirect intention, could be problematic in a case of moral dilemma. Now, what I mean by this is that if the defendant kills for what they think is the greater good. Now, there's no defence to that. If you kill one person to save 30 people, that is still murder, and you will still be given a mandatory life sentence if the jury return a guilty verdict. But some academics suggest that a jury might not do this, and they look to the example of Herald A03 Enterprise disaster, where basically there was a ship that was on fire and everyone had to get off the ship. There was a man, X, who was blocking the escape ladder. He was basically refusing to get off the vessel and therefore preventing everybody else from leaving the ship and getting to safety. Now, another passenger, Y, pushed him off. Now, this resulted in the man drowning and dying. The academics suggest that if this went to court and this was put to a jury, that they would put themselves in that moral dilemma and they would be likely to acquit. And that highlights one of the other issues there is with foresight of consequences being merely evidence. So, on our second big issue, which is the serious harm rule, and again, it is surrounding the mens rea of murder. So we've just looked at Malice Aforethought express. This issue is relating to Malice Aforethought implied. So remember, Malice Aforethought implied is where the defendant intends to cause grievous bodily harm to the victim. So grievous is given its ordinary meaning, and a jury will be deciding whether they think grievous bodily harm was caused. And we know grievous bodily harm also means serious harm. Now, this can be problematic because the defendant can be convicted of murder if they intended to cause serious harm to the victim, and also if they actually intended to kill them. So you could have a situation where two people who intend totally different things get the same sentence, which again comes back to the argument of blameworthiness. And a lot of academics suggest that this needs reforming and that the intention to cause grievous bodily harm is not sufficient for murder. There should be a different offence and a different category so that they can be awarded a sentence more on blameworthiness. So we saw this in the case of Vickers, where the defendant broke into the old lady's sweet shop and his intention was to burgle, but he saw the old woman and the seller and beat her badly and she died. Now, some people might argue he's beaten an old woman and she's died, he deserves to go to jail for a mandatory life sentence. Other people may argue that it's disproportionate because he didn't intend to kill and he could be given the same sentence as somebody who did. Therefore, the law is not taking into account people's intention there. Okay. Moving on to the next issue. So this is moving away from mens rea. Okay. And it's to do with defences. So one of the defences you will study in year 13 is self-defence. So if you are defending your life or a life of another, you can use force as long as it is proportionate. Now, this is where the issue comes in. Now, the word proportionate, okay, we haven't got a legal definition for that, and it's going to be up to the jury to decide whether they think the defendant used proportionate force given the circumstances. But this could be really unfair because let's say you are battling with somebody in your home and you think it's a life or death situation. In the back of your mind, you aren't going to be picking up a bat thinking, is this force going to be proportionate? Is a jury going to allow this defence? You would be thinking about either a family you've got upstairs or protecting yourself or your home. Now, if the force is not classed as proportionate and it's excessive, then you cannot use the defence at all. So it goes from either having a full defence and escaping imprisonment and liability to having zero defence if the jury decide that the force was disproportionate. Okay. Now, this was actually seen in the case of Martin Anthony in 2002. Now, you might have read about this case, and if you haven't, you could type it in online and look at the media coverage of it, because it was a huge campaign in them years. And it was about a farmer. So he'd suffered many break-ins in the past. As a result, he was very anxious. He had other health conditions. He was sleeping with a bat under his pillow because he was so scared of people breaking into his farm. And one night he had a disturbance, and this time he actually disturbed the burglars in his house, and he took a gun and he shot 3 bullets in the dark, and he'd killed a 16-year-old boy who had broken into his house. Now, there was lots of people pushing for him to be cleared of murder, but the jury returned a guilty verdict and didn't accept the defence of self-defence because they said the force he used was excessive. Shooting the 16-year-old boy in the back suggested that he wasn't in danger, even though he had done it in the dark. Now, he was able to use a different defence, okay, because of the underlying health conditions that he had, and we'll have a little look at this case again in manslaughter. But in terms of using self-defence in murder, he was unsuccessful because the force was excessive. Now, there has been some resolve to this issue by Parliament, as they introduced the Crime and Courts Act 2013 to try and tackle this issue, since there was a massive push by the public that they wanted to be able to protect themselves and their homes more. And what it basically does is in householder cases, which are cases where there is a burglar in your property or on your land, you can use a greater degree of force to protect yourself. And now you will be able to use the defence of self-defence unless your actions are grossly disproportionate. So we don't have to just have force as proportionate. As long as it isn't grossly disproportionate, then it will be allowed. However, there's still no clear-cut definition on what grossly disproportionate is. It will be up to a jury to interpret and decide, given the circumstances and the case. So there could still be some issues with that. So, on to our next issue. And again, this is looking at another defence. And it's looking at the defence of duress. Now, duress is a defence you can raise if somebody has forced you into committing a crime. And you will only be allowed to successfully use it if your life or the life of somebody else, so let's say a close family member, is in danger unless you commit that crime. So let's say you are held at gunpoint by a gang and they say, if you do not go into that post office now and rob the cashier and get this money, I'm going to shoot you in the head and kill you. And you believe that to be true and you fear for your life and you do it. You could raise the defence of duress to say you would not have committed that crime was it not for the threat to your life. However, duress cannot be used for murder. And this is criticised because you've got a really hard situation where you could be weighing up your life and the life of another, which nobody wants to do. And this was actually quite relevant in the case of Gotts, which you've had a little look at previously. So just to remind you about Gotts in 1992, you've got the stepfather with a gun to his teenage stepson's head, basically saying, if you do not stab your mother now, I'm going to kill you. So he was in the impossible position of fearing for his own life, not wanting to stab his mother in fear of really seriously harming her or killing her, and not wanting to be shot in the head and killed himself. Very distressing situation. Now, the teenage boy did stab his mother, and fortunately she did not die. So in that case, the judge was able to award a community sentence because it wasn't murder. However, if the mother had died and the jury would have returned the guilty verdict, he would have had no choice but to award the teenage boy a mandatory life sentence. And that just does not seem fair. Again, going back to the idea of blameworthiness. You've got somebody setting out to kill someone, and then you've got somebody who is being threatened with their own life, both getting the same sentence. adding on to that is the issue that you looked at with mercy killings. So you had a look at the case of Inglis in some depth, where the mother had given her son an overdose and killed him out of what she says was mercy and love. So she believed her son had locked-in syndrome after he had a bad accident, and she believed he did want to die. And to put him out of his misery and give him that choice she believed he wanted, she did kill him. And the jury returned a guilty verdict. Now, the judge, again, could not take into consideration her circumstances, blameworthiness, or the fact she did it out of mercy. They had to award her a mandatory life sentence. So, those are the 5 issues that there are with murder. If you want to read about those in a little bit more depth, you can have a look at the Law Commission report in your workbook, or you can actually look up the full report online, or have a little look in your Jacqueline Martin textbook. Okay, I hope that's helped you. Thank you for watching. Take care.